So today we're going to talk about planning for tomorrow, a no frills guide to planning for tomorrow. All right. Oh, all right. So, okay. Our firm is an elder law firm and an estate planning firm, and we generally do a little bit of public benefits work, and we do a little bit of estate planning. We do a holistic approach because we have care coordinators on staff. So I've got a licensed clinical social worker, a geriatric care manager, and an RN. So the focus of our firm is really making sure people get the care they need. Figuring out how to pay for it is my job. There are 4 attorneys at my office currently. 3 of us are certified elder law attorneys. One is an elder law attorney. So our care coordinators, I've got 3, as I said, a licensed clinical social worker, a geriatric care manager, and an RN. And they serve as the point of contact for the family, and they assist in coordinating services to make sure that the client is taken care of. They can answer questions, provide support, go to care plan meetings. They can identify problems and help fix them. So our agenda today, we're going to talk about what does a comprehensive plan for the future look like? We're also going to look at briefly at Medicaid, the Medicaid program, and the VA aid and attendance program. I can't make that work. Okay, so what does a comprehensive view of planning look like? It means that you are planning during life. You're also planning for incapacity. You can plan for a medical crisis, long-term care, and you have to figure out where you want your assets to go upon death. So there are 5 documents that every person generally should have. I know my slide says over 55, but generally everyone should have them, particularly if you're over the age of 18. So you need a power of attorney for finances. So this is a document that nominates whoever you want to take care of your bills for you, so they can manage your legal and financial affairs when you're incapacitated. A financial power of attorney nominates the person who makes healthcare decisions for you if you're incapacitated and can't do that for yourself. A living will, which is essentially your instructions for your healthcare power of attorney. It indicates what your medical treatment preferences are when you're unable to speak for yourself. An advanced care directive is a more thorough legal version of the living will. And the last will and testament, or a trust, it's a way to dispose of your property at your death. So your power of attorney documents, these are they only grant powers to another individual that are listed in that document. So it's not it can be a wide range of things, or it can be very customized, and it can be very narrow as to what that person can take action for you on your behalf. Generally, these are interpreted by other attorneys at either banks or medical institutions. So they have to be very clear as to what powers you intend to grant to that other person. If the document itself doesn't list out an action, then it's not included and you can't do it. The power of attorney is ineffective. It terminates at death. And if you sign a power of attorney in any state and it was validly done while it was in that state, it's valid all over the United States. So your medical directive. So these only come into play when you cannot speak for yourself. So if a doctor will always ask the person first, or see if the person can communicate their wishes. If they cannot, then they look to the healthcare agent, and the agent has the directives which provide the direction as to treatments that they may or may not want to receive. So the primary difference in a will and a trust has to do with essentially where you do the planning and where you do the work. So a will, you're doing the work after the fact. All you're doing is you're laying out, hey, this is where I want my assets to go when I pass away. It tells who you want to collect your assets, who's paying your debts, and who's disposing of the property. And so all the work falls on that person after death. A trust is the other way around, where you're doing all the work up front. You're setting up the accounts in the trust, you've written the document, you've executed it, you're doing all those things. And therefore it is front end heavy. So you're doing the work for your family. It plans for your property during your life, during your incapacity, and after death. And then generally, Trust can also be used to achieve other goals, like becoming eligible for certain public benefits, protecting your assets from estate recovery, and minimizing tax liabilities and or avoiding probate. So some people are very private and would prefer stuff not go through the courts. Then a trust is your tool there. So things you have to think about when you are doing planning, you have to think about the difference between capacity and competency. So competency is actually a legal finding by a court that a person is no longer able to act. And they do that based on a review of evidence that's presented to them. It doesn't usually describe a person's ability to function. It has to do with their ability to make decisions. So capacity, on the other hand, is a term that's used to describe their person's ability to function. And so the law presumes adults have capacity. So it can be a fluid thing. You're not always competent, or don't always have capacity, and sometimes you do. It is fluid. It can be diminished. What the legal definition is the person has to have capacity in a certain moment in time. So when they're executing the document. So it's a very fluid thing. It can present planning opportunities. So when a person doesn't have capacity, you then are starting to look at conservatorship or guardianship. In Tennessee, we refer to it as conservatorship. Guardianship is for persons younger than 18. And some states use it interchangeably. In Tennessee, we call it a conservator of the person. This has to do with my person. So things that how healthcare power of attorney can govern, that's what your conservatorship of a person governs. So my medical decisions, where I live, the care I receive, treatments, and that sort of thing. In other states, in Tennessee, when we say conservator of the person, other states call that guardianship versus conservatorship. That's their distinction. So in Tennessee, we do conservatorship of the property. And so this is people who are managing what would normally be managed by healthcare finance, financial power of attorney. So they manage your property. In Tennessee, that person has to live in Tennessee. Your conservator of your person does not have to live in Tennessee, but the person managing your property does. Or you have to have a co-conservator and one live in the state. The conservatee, or the person under the conservatorship, is the one who no longer can make decisions. So what a conservatorship is, and the primary difference between a power of attorney and a conservatorship, is that under a power of attorney, this is me, and this is my agent. So I'm naming this person to help me make decisions, but I still have all my rights. I still have my ability to make my decisions. Under a conservatorship, what the law does is they take away my rights and they substitute this person as the only decision maker for me. So it's a very serious proceeding. It's a big deal. I can't decide who I can marry. I can't decide where I live. I can't decide if I want surgery. I can't decide anything. Somebody else is doing that. It's making them a child under the eyes of the law. So the laws encourage very limited conservatorships rather than wide overarching conservatorships, because the law is supposed to encourage the least restrictive alternatives. So if I can make decisions about my health care, but I'm making poor financial decisions, but I'm making okay decisions about my person, then I should be allowed to govern my person and just not manage my money. There are lots of common misconceptions about conservatorship, namely that the courts award them all the time. I'm sure you all have seen that movie on Netflix. That they're easy to get, that anybody can serve as a conservator, that there's a lot of abuse and fraud, and you can't require medical treatment or medications. You can, and not all of this is true. So there are some pitfalls when you're undertaking this process. And there are a lot of things that can trigger a need for a conservatorship, such as failing to plan. If you're unwilling to do the financial power of attorney, you become incapacitated to the point where you don't have capacity at the moment, at any moment, then you have to go through this proceeding and I have to have all my rights taken away from me, when instead I could have had just somebody helping me. There are issues where children can use it sort of as a custody battle over parents, who knows best, and then losing sight of the quality of life, best interests, and the needs of the elder. So There are other alternatives to conservatorship, such as supported decision-making. Supported decision-making has certain assumptions that underlie it. They assume that all individuals have a fundamental right and ability to make choices, that adults usually consult advisors to assist with life decisions, and that well-informed decisions of an individual should be supported, should be honored. Supported decision-making, to quote, it says, a person-centered model that can empower an individual to make choices with the guidance from trusted advisors. The advisor is tasked with explaining the facts and issues, making recommendations, and helping the individual communicate choices, and then honoring his or her choices. The model can empower a person with cognitive impairment to remain engaged in the decisions that are impacting their lives, even as the disease progresses. So it also has to do with the fluidity of capacity. So sometimes you can make decisions, sometimes you can't. And sometimes you have greater capacity if you're given the help with understanding. So the assessment of capacity generally involves the individual capacity and skills. So if there's sensory impairment, motor impairment, cognitive impairment, you look at a person's life experiences, their environment, their preferences and interests, available supports. And then you, of course, have to factor in your risks and what the expectations are. So this is a chart that would be helpful for y'all to see, but it looks at what level of support and planning is appropriate based on different levels of capacity. So generally, up and until permanent serious impairment, there are certainly options for powers of attorney, wills, and trusts to be completed. It really just becomes an assessment of the moment in time and where the person is and as to which way you're going. So when you're looking at paying for long-term care in Tennessee, our Medicaid program is called Choices. It is a program that offers assistance with paying for care either in the home, so by providing caregivers, paying for care at an assisted living, or paying for care at a nursing home. Medicaid, TennCare, and Choices are all three terms that are used interchangeably, and it means the same thing for our intents and purposes if we're talking about long-term care. So there are multiple sources of regulations that are governing Medicaid, which is why it can be so confusing. It's managed by federal law, it's managed by state law, it's managed by state rules, and it's managed by a policy and procedure manual, which is telling the workers how to interpret the law. So these can be conflicting and it can be very confusing. So there are three phases of eligibility for the program, of three phases of the program. There's eligibility, there's enrollment, and there's after death, so estate recovery. For eligibility, we're talking about the eligibility requirements, we're talking about the application. When you're enrolled, of course, we need to know what are my benefits, and we have to know what are my responsibilities, how do I maintain my enrollment. After death, then we're talking about estate recovery. So eligibility. The application process does become harder every single year. You have to submit financial records for the applicant and the applicant's spouse if they're married. The eligibility requirements are both medical and financial. So medical, you have to meet a certain level of needing assistance. It's called the process is called a pre-admission evaluation, or PAE. And a person has to score 9 out of 26 points to qualify. It doesn't sound like a lot, but again, TennCare is doing their best to restrain what you get points for. Importantly, for persons with cognitive impairment that can still functionally, physically do their activities of daily living, there is a process called a safety determination, which is exactly what it sounds like. Is it safe for the person to live where they are should their supports be removed? So financially, they look at a person's income and they look at assets. The applicant's income has to be below roughly $2,500. There's a way around it, but that's the general rule. And the applicant themselves can have assets totaling $2,000, other than a house and a vehicle and a few other things. If an applicant is married, their spouse can keep up to roughly $137,000 a year. $137,000 depending on what their assets were when they started. So Phase 2 is enrollment. The benefits that Medicaid Choices provides is assistance with paying for care. Of course, they provide TennCare health insurance. In addition to the Medicare coverage, you now have TennCare health insurance. And your responsibilities. Enrollees have to pay a patient liability, which is based on their income. Essentially, that's sort of like a copay that you pay at your doctor's office. So after a person has passed away, TennCare sends you a letter and says, oh, we're so sorry for your loss, but we know we've spent X number of dollars on your loved one during their lifetime. And oh, by the way, they have a house. You have to sell it and pay us back. That's what estate recovery is. So they can recover assets belonging to that person who received benefits as reimbursement. So TennCare is really a loan, like you're getting the advance and then you have to repay TennCare. Tennessee doesn't put liens on property. That's a common misconception. They only do that unless the applicant has committed fraud or acted in bad faith. In most states, the state's claim just sort of hangs out until the family tries to sell the property, and then it hops up and you got to get paid. So probate administration and real transfers require a document from TennCare. So it's either a release saying, hey, that person never got benefits, or it's a bill and says you got to pay this. That's usually how estate recovery is initiated in Tennessee. So that avoiding that tends to be a priority for a lot of families. So you can protect assets by planning ahead. The earlier you plan, the better. Trusts can be used to protect those assets if you plan far enough in advance because of that look back period in Tennessee. So before you transfer property to another person or add somebody to the deed, you have to consult an attorney to make sure you're not doing something that would make you ineligible later on in the future. There are certain risks associated with gifting the property. There are safer methods that exist, so that's one. Adding a child to a deed can be risky, and it's not appropriate in every situation. So transferring property for less than fair market value can create unintended tax consequences and can make the previous owner ineligible when it comes to Medicaid or VA benefits. So the issue with gifting to a child can be that when you're filing an application for TennCare, you have to report all gifts made in the 60 months prior to the date of your application. So gifts are defined as transfers of property or of anything really for less than or below fair market value, and includes giving property away by a deed, retitling assets, or transferring money. So it can create one, unintended tax consequences, because for now we still have a step up in basis, and it also could make the previous owner ineligible. There are gifting strategies that you can use to protect assets when it's appropriate. Except it's more of strategic gifting instead of willy-nilly gifting. Another benefit that elders can use to help pay for long-term care is the veterans benefit called pension with aid and attendance. This is it's a non-service connected benefit, so you don't have to have been injured during service. It's a benefit that they're entitled to just because they served, and we owe veterans for that. So it's essentially, it's different from Medicaid in that it's a cash payment paid directly to the veteran or the surviving spouse. So roughly, if it's a wartime veteran with a surviving spouse, it's $2,400 a month, roughly. It's about $2,000 for a single veteran, $1,700 for a veteran with an ill spouse, and about $1,300 for a surviving spouse. So it's ideal for home care or assisted living care where your care needs are less complex and you've got just not quite enough money to pay for the care you need. It's usually not great for nursing home care unless they can receive care in a VA certified facility or a state veterans home. It's typically not enough money for a nursing home care cost unless they've got exceptionally high income. The eligibility requirements to receive this benefit are that the person have served 90 days of active duty service. At least one of those had to have been during a congressionally declared period of war. You have to have received other than dishonorable discharge, and you have to have less than $138,489 in countable assets. Some assets are exempt, usually a home on less than 2 acres, a vehicle, a prepaid burial and funeral. And the VA does also have a look back period, except theirs is a 3-year look back period versus Medicaid's 5. They're also looking for gifts made for less than fair market value. So the VA wartime periods are listed here. We've got World War II, Korea, Vietnam. Vietnam is harder when you have a veteran because the bulk of the Vietnam War was actually conducted under a presidential action, not a congressional action. So they had to pass special legislation to cover Vietnam. So there's a difference during the presidential action if you were actually boots on the ground or if you were in the water outside of Vietnam versus if you were in the military during those dates, but just like in Germany or something, you may not be eligible for this benefit. And that's my presentation today. Any questions anywhere? I don't have any on here, but no?
On the 10-care reimbursement, is they go for 100%, or do they accept up to a point and then settle? How do they?
Nope, they want to get paid for every amount that they spent out on care. And they can claim different things as a, not to get too far in the weeds, but there are different benefits programs. And like, if you're in one of the Medicare savings programs, they can try to recoup other amounts, but yeah, all of it.
So what happens with they don't have any assets? They have no land. They have.
Then there's just a bill hanging out in somebody's file cabinet.
Okay.
Yeah, because I mean, the only person responsible for my debt is me. And if I have nothing when I die, then there's nothing they can do. Yeah.
So they just go back into the estate. They can't go after children.
Yes, they just go to the estate, not after children or anything like that. But if I don't have an estate, then, then there's nothing. Yeah, absolutely. Well, thank you. Okay. Well, thanks everybody.
Thank you.